As far as the UNCITRAL rules are concerned, it is very clearly provided in Article 3 that these are the requirements that need to be in a notice of arbitration. Number one, the words are you need to demand that a dispute be referred to arbitration. So to avoid any argument, please ensure that the words in your notice of arbitration are clearly set out that you are demanding that the dispute between the claimant and the respondent to be referred to arbitration. Number two, to insert the name and contact details of the parties. Number three, identify the arbitration agreement. Where is this arbitration agreement contained? Is it in a form of a clause in a contract? Is it in a form of a separate arbitration agreement? Is it in a form of an exchange of letters or a new agreement entered into between the parties? Or is it incorporated by way of reference?
An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. From these two options, we can see that there are two types of arbitration agreements. One for existing disputes, and they are called submission agreements or compromis, to use the French terminology, and one for future disputes. Those are called arbitration clause or clause compromissoire. The first would commonly be a self-standing agreement drafted specifically to serve the purpose of agreeing to arbitrate an existing dispute, while the second would commonly be a dispute resolution clause in a contract designed for a business relationship rather than a dispute. The literature says that the two types of agreement are different, but they don't have to be. They may differ in content, as an agreement for an existing dispute can be more focused, designed to suit the needs and characteristics of a known issue.
Arbitration is a private, non-national system of dispute resolution by an impartial tribunal. So you take yourself out of the court system into a separate system for resolution of disputes that is not tied to any particular national system of justice. We'll come on to certain ways in which there are links, but it's outside of the judicial process of any country. It's based on the parties' agreement. If you don't have an agreement to arbitrate, then you default back to local court jurisdiction. The award is final and binding, so it is an enforceable decision. As a general rule, there is no appeal on fact or law. There are limited exceptions to that under the laws of certain seats that often can be excluded by agreement.